Hi everyone, this is Megan Caldwell. I'm a partner at Husch Blackwell, and we are excited to welcome you to the fourth installment in the Emerging Environmental Law Trends webinar series. So we're going to be talking to you today about a gamut of regulations causing heightened scrutiny, including the Toxic Substances Control Act, Occupational Safety and Health Administration's Safety Data Sheet Requirements, California's Proposition 65, the California Cleaning Product Right to Know Act, and the European Union's Registration, Evaluation, Authorization, and Restriction of Chemicals Program. So before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today, and I'd like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. If we have time, we'll try to answer some of these questions during the webcast, but otherwise we will reach out directly to you via email to answer your question later. We truly appreciate audience participation, and we encourage you to submit questions. There's also an icon to assist with your viewing preferences. Note that you can expand your slide area by clicking on the Maximize icon at the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click on the Help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the Resource List icon that looks like a folder at the bottom of your screen. The program has been approved for continuing legal education credit in the states of Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, and Texas. Wisconsin CLE credit is pending. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. You will need your bar number to submit. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. Joining me today is Amy Watts, a partner also at Husch Blackwell. Amy and I both focus our practices on providing practical legal advice targeted to each client's need to integrate environmental, health, and safety regulatory compliance into everyday operations, ensuring that our clients' businesses run smoothly and successfully. And with that, I'm going to turn it over to Amy to introduce our topic today.
Great, thanks Megan, I appreciate it. Good afternoon, I guess it is afternoon, 12:03. For those of you, except for Megan in Denver, it's still morning. Megan and I have been getting a lot of questions from product manufacturers and suppliers and also from retailers regarding questions that have been coming up and down the supply chain asking product manufacturers to certify certain chemical information about products. And we thought this would be a really good opportunity to update you all on what's going on in chemical regulation, because that is what is prompting all of these questions that are coming up and down the supply chain. I have, just a mock-up of some of the questions that people are being asked, and retailers are asking this of their suppliers. Suppliers are asking it, well, they're asking it of the distributors. Distributors are asking these questions of their suppliers. Suppliers are asking it of their suppliers. Manufacturers are asking it from their suppliers. These questions are going up and down the supply chain. And the common things that people are getting is, does this product contain any chemicals known to the state of California to cause birth defects or cancer? Are these chemicals subject to any use restrictions? Any substances of very high concern? Is there PFAS, phthalates, methylene chloride, etc.? What is all that stuff? So we thought this would be a good opportunity for us to update folks with what's going on with chemical regulation and let you all know what we see is coming. What we see is coming right now is like I said, the inquiry up and down the supply chain. The supplier inquiries, inquiries of suppliers and by suppliers, they're not standard. Everyone seems to have their own requests. They're based upon regulatory requirements for products, but also on various customer priorities. So we are going to be talking today about what some of the regulatory requirements are regarding chemicals in products. There are an awful lot of end users that have their own priorities. So they want to see products that are made in certain green ways, for example, that they may not be regulatory requirements, but we're at this point going to be talking about regulations. The information that's being required is becoming more detailed. The trend we see is that these information requests will increase. They're becoming more precise. I know in the beginning people were responding very vaguely saying, we think we might have chemicals, but nothing above 1% or something like that. We're getting a lot more requests now that are like the one I saw on the first slide, which says, yes, do you have it, or no, do you not? Very precise, no caveats. So we want to give you some of the background information that can help arm you in deciding how you're going to respond to these. The first thing we're going to talk about is the California Proposition 65, because it's sort of the mother of all requests. Pretty much everybody is asking for information that's relevant to California Proposition 65, and Megan's done quite a bit of information on that, so I'm going to hand this over to Megan so she can let you know what's going on with Prop 65.
Great, thanks, Amy. So, Prop 65. So a lot of you may be thinking, well, this doesn't apply to me. My business doesn't have any locations in California. Unfortunately, it's not quite as simple as that. The question is whether your business is involved in the production or sale of any components or products that may ultimately end up in the hands of California consumers. So this law was passed back in 1986 by California voters who approved the initiative to address their growing concerns about exposure to toxic chemicals. It became the Safe Drinking Water and Toxic Enforcement Act, but it's better known by its original name of Proposition 65. So Prop 65 requires the state of California to publish a list of chemicals known to cause cancer or birth defects or other reproductive harm. The law also requires businesses to notify Californians about significant amounts of chemicals in the products they purchase in their homes or their workplaces or that are released into the environment. So the idea is that by providing this information, Prop 65 enables Californians to make informed decisions about protecting themselves from exposure to these chemicals. The California Office of Environmental Health Hazard Assessment, or OEHA, administers the Prop 65 program. And OEHA, which is part of the California Environmental Protection Agency, also has a role in considering whether substances should be added to the Prop 65 list. So what types of chemicals are on the Prop 65 list? The list, which must be updated at least once a year, has grown to include approximately 800 chemicals since it was first published in 1987. The list contains a wide range of naturally occurring and synthetic chemicals that are known to cause either cancer or birth defects or other reproductive harm, and sometimes both. The most targeted chemicals by Prop 65 enforcers are phthalates, which are essentially plasticizers, heavy metals such as lead, flame retardants, and BPA, but other chemicals are certainly targeted as well. So who enforces Prop 65? The California Attorney General enforces Prop 65. Also, any district attorney or city attorney may also enforce. But primarily, any individual acting in the public interest may enforce Prop 65 by filing a lawsuit against a business alleged to be in violation of the law. 9 times out of 10, enforcement is done by these private citizens teaming up with law firms. So what requirements does Prop 65 place on companies doing business in California? Businesses are required to provide a, quote, clear and reasonable warning before knowingly and intentionally exposing anyone to a listed chemical. The warning is typically given by labeling a consumer product either on the product itself or on its packaging. There are both long forms and short forms allowed under the current safe harbor language. Internet sales must also include warnings. Businesses must include the Prop 65 warning language on the product display page or on a clearly marked hyperlink using the word warning on the product display page or prominently displayed to the purchaser prior to completing the purchase. So who is responsible for Prop 65? Well, really any person doing business in California is responsible, i.e. the entire supply chain. So we've got manufacturers, distributors, retailers, etc. But the responsibilities on a retail seller are somewhat reduced. So a manufacturer, producer, packager, importer, supplier, or distributor must affix a label to the product bearing a warning or provide written notice directly to the retail seller that a warning is required and include all warning materials, and then must renew notices at certain intervals after that point. On the contrary, a retail seller has sort of a diminished role. So upon receiving that warning label, a retail seller must affix the warning to the product, and otherwise they're only subject to independent Prop 65 liability in a certain number of limited circumstances, like for instance, where no one higher up in the supply chain is subject to Prop 65, such as where the retail seller's vendors are all from outside the U.S. So another important topic to discuss is safe harbors. So if a warning is placed on a product label, the business is essentially saying that it's aware of or believes that one or more listed chemicals is present. By law, a warning must be given for listed chemicals unless exposure is low enough to pose no significant risk of cancer or is significantly below levels observed to cause birth defects or other reproductive harm. So businesses are exempt from the warning requirement, and if they have exposures that are so low as to create no significant risk of cancer or birth defects. So OSHA has developed numerical guidance levels, which are known as safe harbor numbers. And a business has a quote safe harbor from Prop 65 requirements if exposure to a chemical occurs at or below those levels. There are 300 safe harbor levels that have been established to date, and that list continues to grow, but that does mean that most Prop 65 listed chemicals don't have safe harbor levels, because we're talking about 800 plus Prop 65 listed chemicals. Lead, for instance, has safe harbor levels, but phthalates, which are really a priority group of chemicals targeted, do not have safe harbor levels. The problem is if there's no safe harbor level, the burden is really on businesses to determine whether a warning is required. And even if a safe harbor level has been established, they are defined as exposure levels, not concentrations in the products. That's one of the main challenges of Prop 65, is that it's an exposure-based law. So determine that a product comes in under the safe harbor level would arguably require an exposure assessment to be conducted, and those are really, really expensive. Another reason that Prop 65 is so tricky is that Prop 65 reverses the burden of proof. Once a Prop 65 enforcer can show a chemical is present, a business is required to show that the product does not cause exposures at certain levels or qualifies for an exemption or defense. So a business is really sort of guilty until proven innocent under the Prop 65 structure, which can be really frustrating and challenging. So let's chat for a moment about the Prop 65 process. So if you have a business that you receive a letter, it's called a 60-day notice. That notice basically says, hey, we think you violated Prop 65, and we have the right to sue you 60 days from now in court. That sort of kicks off, a question of what do you do to handle it? So you evaluate the claim. You figure out, is this claim valid? Do we take internal corrective actions and contact the opposing counsel, hire a lawyer, try to figure out whether we should potentially settle this or fight it? If you go down the settlement route, then there's sort of two routes. One is you can do an out-of-court private settlement, or you can go the in-court route where you essentially have the court approve whatever settlement you reach. If you feel really strongly based on laboratory testing or some other evidence that the claim is not valid, you can press for withdrawal of 60-day notice. There's also instances where you don't reach a settlement, and then the Prop 65 enforcer will potentially threaten litigation. So penalties for violating Prop 65 by failing to provide notices can be as high as $2,500 per violation per day. That's a very theoretical amount, and it almost never amounts to that. A small portion of any settlement will be the penalty that goes to the state. Another small portion goes to the plaintiff, who's the California consumer. The vast majority of the settlement amount goes to the Prop 65 enforcer's legal counsel. That's right, to the legal counsel. So this really strikes a lot of businesses as quite a racket. The Prop 65 consumer legal teams are known by many as bounty hunters because of the way they essentially extract settlements at a quite alarming pace with quite a bit of success. There are exemptions and defenses that a business can raise. For instance, businesses with less than 10 employees and government agencies are exempt. There's a safe harbor defense, which we discussed. There's a defense for naturally occurring chemicals. You can allege that the 60-day notice letter was faulty. You can argue statute of limitations and things of that nature. So to step back, let's talk briefly about how to ensure that compliance with Prop 65 is occurring to avoid Prop 65 notices in the first place. So there's sort of two main strategies. One is to conduct sort of a preventative Prop 65 audit, where you take a look at the products or the components that your business produces, and you involve a laboratory to test those products. And then you roll out warnings as appropriate, and then you work to contact your suppliers and your customers. Another strategy is basically skip the testing and apply blanket warnings to all of your products. This is definitely a tried and true strategy. Prop 65 guidance says that businesses are discouraged from doing this, but we're not seeing enforcement of overwarnings yet. So it's really a business decision what strategy works best for the business. Overwarning can lead to more questions from customers, and in theory, a decline in sales due to concern. But that being said, you really have to ask the question of, do consumers even notice Prop 65 warnings these days? They've become somewhat ubiquitous, and there's some suspicion that consumers don't really care about the warnings. So to close up the discussion of Prop 65, what sort of trends are we seeing in the Prop 65 world? New safe harbor warning language was rolled out in the summer of 2018, and in the Prop 65 world, we've all been discussing whether the new regs would result in an uptick in enforcement or not. We at Husch have not really seen much of an uptick. Enforcement is sort of regular and steady. We have seen some pushback from the Attorney General, which is encouraging for many of our clients. Most recently, the AG is rejecting a lot of notices for a phthalate called DINP, saying that Prop 65 enforcers' evidence has not been sufficient. It's possible we'll see more pushback like this in the future, but it's hard to know. We're also seeing the rollback of some requirements. Coffee, for instance, it was determined that a warning was required for coffee due to it containing the chemical acrylamide. I'm sure a lot of you have seen, the news when that happened, but recently that requirement was struck down in court. We're also seeing more enforcement regarding packaging, where the enforcers essentially allege that the chemicals are not contained in the product itself, but in the packaging that the consumer handles. So we've argued so far pretty unsuccessfully that because the exposure is very limited to the packaging, Prop 65 shouldn't apply. But Prop 65 unfortunately does not have a defense based on the frequency of exposure. One exposure is enough. We haven't really seen this pop up in any reported cases either. And then aside from California, last year the New York governor announced a proposal to add stringent labeling requirements for certain products sold in New York through what they were calling the Consumer Right to Know Act, which would require on-package labeling requirements for products containing any of more than 1,000 carcinogens and other chemicals. There hasn't been much discussion on this proposed act at this point, although California and New York are at the forefront of the push for more chemical regulations. It's absolutely possible that other states will start considering enacting laws similar to Prop 65. So that wraps up the discussion on Prop 65. I want to talk briefly about another California law that's also creating some obligations for businesses, and that's called the California Cleaning Products Right to Know Act. So back in 2017, California enacted this act, which requires manufacturers of cleaning products to disclose ingredient information on both the product label and on the company's website. In terms of when it goes into effect, so the online ingredient disclosure requirements apply to a designated product sold in the state on or after January 1st, 2020. So the online disclosure requirements went into effect just a few weeks ago. Separately, the product label disclosure requirements apply to a designated product sold in the state on or after January 1st, 2021. So in other words, so the online requirements are in effect, the product requirements are not yet in effect. Products manufactured prior to that date are not subject to the disclosure requirements, provided they display a date of manufacture. But that January 2021 date is going to be here before we know it. So businesses, we really do recommend businesses get ready to comply with the product portion of the program. When does the Act apply? Well, it applies to, quote, designated products that in turn are defined as finished products that are in an air care product, automotive product, general cleaning product, or a polish or floor maintenance product used primarily for janitorial, domestic, or institutional cleaning purposes. So if those products contain ingredients included on a designated list, then a business must provide an ingredient disclosure. In order for the Act to apply, the designated product must also be sold in the state of California. A number of products are exempt, for instance, foods, drugs, cosmetics, and certain personal care items like toothpaste, shampoo, hand soap, and hand sanitizers. Also exempt are industrial products specifically manufactured for and exclusively used in a number of industries, such as oil and gas production, steel production, etc. And then lastly, trial samples of products not individually packaged for sale are exempt. So who must disclose? Well, the manufacturer has primary responsibility for disclosing ingredients in covered products, but the Act defines manufacturer in such a manner as to also include private label distributors in addition to traditional manufacturers. And from California's perspective, if there's a reason to question a product's compliance with the disclosure requirements, the official inquiry will typically start with the entity whose name appears on the label, i.e. the private label distributor or manufacturer. So what's the method and content of disclosure? Well, the Act requires ingredient information to be disclosed on both the product label and the manufacturer's website. And the Act contains specific requirements and options for ingredient disclosures for both on-product and website disclosures. And then there's a certain, essentially, list of information that must be included in each disclosure. So what happens if a company does not comply? Well, if a product doesn't comply, it cannot be sold in California. Under the state's unfair competition law, lawsuits could be filed seeking civil penalties of up to $2,500 per violation. So because this law is so new and just went into effect for website disclosures and isn't yet in effect for product disclosures, we aren't seeing enforcement yet, but much like Prop 65, we expect to see enforcement ramp up. It's absolutely possible that a bounty hunter structure will crop up, much like in the Prop 65 world, where law firms are essentially created that focus on enforcement of the Cleaning Product Right to Know Act and that substantially profit from violations. So taking early efforts to comply is really, really key here. We're also seeing this type of law get traction in other states. In New York, again, specifically, an ingredients disclosure law was proposed called the Household Cleaning Product Information Disclosure Program. However, in a lawsuit brought by trade organizations, a New York judge issued a decision last August to invalidate the New York program. So that has been tabled for the time being. However, similar legislation is pending in Maryland, Minnesota, and Oregon, and possibly other states. So that leads me now to the third regulatory program, and I'm just going to talk for a brief moment about this, but these are essentially called green chemistry laws. Many states have enacted or are positioned to enact so-called green chemistry laws, which attempt to address the use of numerous chemicals in products, typically by establishing a list of chemicals of concern or high concern and requiring reporting. This approach adopts a right-to-know principle and focuses on reducing long-term risks to human health and the environment. And we're not going to go into detail on all these laws, as they really do vary state to state, but they're absolutely something to be aware of. There are some great multi-state surveys out there to use as a resource when you're determining what green chemistry laws might apply to your business and its products. The difficulty, of course, is that the legal landscape is constantly in flux. New laws are being enacted while others are being amended and struck down. So it's a pretty tricky situation, and adding to the confusion is that some of the laws only apply to children's products while others apply to all consumer products. All that being said, because a lot of the chemicals covered by, for instance, Prop 65 and some of these green chemistry laws and other chemical regulatory programs overlap, businesses that invest time and money in investigating the chemical contents of their products can really use that knowledge and that effort across the board to ensure compliance with numerous laws and regulatory programs. Also, there's a suspicion that the somewhat recent enactment of new regulations under the Toxic Substances Control Act, which Amy will discuss here shortly, may slow or halt the expansion of new state green chemistry laws in coming years, but time will tell. So that wraps up the discussion on green chemistry laws. I'm going to turn it over to Amy now to chat with you about the Toxic Substances Control Act.
Thanks, Megan. It's a great transition because we started talking about the state laws here because there was a great concern about the fact that every state wants to take its own path on chemical regulation in products. And there was beginning to be a tremendous concern among the business community that if you're going to have 50 different state approaches, even within the United States, it was going to be increasingly difficult, if not impossible, to comply with every little state requirement. Not that any states are little, but I mean the particular product requirement. So this led to what most people would consider remarkable, and that is a bipartisan major piece of legislation that was passed without any fanfare or CNN talking heads screaming at each other about whether we needed this law. It was a revision to the Toxic Substances Control Act, which was a chemical regulation law in the United States that was passed in the 1970s and has been in place and since then, and was cooking along pretty well, but there were a lot of provisions of the Toxic Substances Control Act that lots of folks thought were insufficient. And so they were able to craft a law that everyone, meaning the business community and most of the environmental groups, thought was a reasonable compromise, and we passed the new TSCA. One of the things that most people knew was coming, and that is as the new TSCA starts picking up steam, there will be a lot more regulation of chemicals that are out in the marketplace, things that have been used for years and years and years. But at least we know that that the regulation is going to be national in scope, and it's going to cut off some of the initiatives that might otherwise have come from individual states. Now, the U.S. has been regulating chemicals since the 70s, and there are two major provisions of the old TSCA. The first provision is that all chemicals that were in use in the 1970s were grandfathered, which means TSCA creates an inventory of all chemicals in use in the United States, and that's called the TSCA inventory list. The major provision of TSCA is if a chemical is on the list and it's not restricted, you can use it. You can use it any way you want. There's no regulation of that chemical. I'm not, obviously if it gets emitted to the air, there are air emissions, it goes into water, there are water emissions, but just the use of the chemical is unregulated. So what they did is they grandfathered all the old chemicals, and every new chemical that someone wanted to manufacture or import into the United States after the date of the old TSCA had to go through a review process at EPA. Now, the review process, a lot of folks were thinking was not rigorous enough. So a lot of new chemicals were routinely approved and put on the list, or actually the way old TSCA worked was if EPA didn't object, it went on the list. Now what new TSCA says is that all those old chemicals are still on the TSCA inventory list, but these chemicals will be subject to review. And I'll talk in a minute about what that review is going to be. And all new chemicals will be reviewed under a more stringent test. So it's an enhancement of an existing law, but it is the same TSCA that we've had for the last 30 years or 40 years. Now, under the new TSCA, with new chemicals, is still the same as any chemical that's not on the TSCA inventory list is a new chemical. And before a new chemical can be manufactured or imported, so this is important because a lot of folks who are importing things that are already manufactured don't realize that they have to make sure that before a chemical gets imported into the U.S., except for narrow exceptions like research and development purposes or maybe test marketing, a pre-manufacture notice is filed with US EPA. Now, under the new TSCA, before US EPA can approve a new chemical, it has to determine that the chemical, and there's a new safety standard. It's a new standard that EPA has to determine that the chemical meets this safety standard before they can put it on the list. So the safety standard is that the chemical is not likely to present an unreasonable risk of injury to health or the environment without consideration of cost or other non-risk factors, including an unreasonable risk to a potentially exposed or susceptible population under the conditions of use. The couple of things here are really key. It's unreasonable risk of injury to health or the environment and under the conditions of use. So that opens up the idea that there are some uses for a chemical that are just fine. It doesn't need to be regulated, whereas there may be other uses where a chemical has to be regulated. And that's where a lot of the action seems to be going. So what EPA does with new chemicals is they say if it is safe for all uses, then they impose no restrictions, and chemical goes out on the inventory just like it used to, and the chemical will be in use in the United States without restriction. But what they're now looking at is they're looking very carefully on uses. And right now they're looking at what uses, they're going to approve chemicals sometimes only for specified uses. And a use can also be restricted. So you can say, well, you can use a chemical in this way, but only if your employees all wear specified personal protective equipment and any waste materials are incinerated or however they decide that those chemicals have to be handled. So there are restrictions on the use. So over time, US EPA will begin promulgating, and this is not new. There have been significant new use rules in place for a while, but this is going to accelerate because while we're looking at almost every new chemical EPA is looking at, they're looking at any use. For example, they'll look at a specific use of that chemical. That's what the person who wants to manufacture or import the chemical for. They'll give them a condition of use, and then EPA is looking at whether they're promulgating a significant new use rule that says if you're going to use this chemical for any other use, then you're going to have to go through this whole review process all over again. And that's where a lot of the interest is moving right now. But what we'll see is we'll see a lot more significant new use rules that will codify some of these restrictions that EPA is putting on the use of new chemicals. So as you will see, as time goes on, a lot of people will be asking, are there any significant new use rules that are applicable to any chemicals in a particular product? Now, the lot of action, which is completely new, is what's happening with these old grandfathered chemicals. EPA now is going through a process where they prioritize the chemicals that are on the list as either high priority or low priority, and then they are picking 20 chemicals at a time. They first had a first list of 10 chemicals, and then there are 20 chemicals they will always have on a list. So it'll be a rolling list where they go through 20 chemicals at a time, where they'll do a risk evaluation of chemicals that are already on the TSCA inventory list to determine whether the chemicals meet the safety standard. That same safety standard that I was talking about before with new chemicals, that one, was there unreasonable risk of injury to health or the environment without consideration of cost or other non-risk factors, including unreasonable risk to potentially exposed or susceptible subpopulations under the conditions of use. In other words, they're going to go through this review for all chemicals one at a time. And once they've gone through that risk evaluation and that review, they're looking at what they call a risk management step, and they may be promulgating significant new use rules or other types of requirements for the use of chemicals that have been unrestricted in the past. And a lot of people think, oh, well, that's going to be some weird kind of strange chemicals that we don't know anything about. No, that's not true. The first 10 chemicals that EPA picked to review are chemicals that will probably be familiar to a lot of people. Obviously, asbestos is right on the list, and the reason why that's on the list is that EPA tried to ban the use of asbestos under the old TSCA, and the court struck down that ban because they said TSCA didn't, check all the boxes and do all the things it needed to do to ban asbestos. And after that point, EPA just gave up. It was too difficult for them to be able to prove all of the standards under the old TSCA to ban a chemical. Now they're picking up on asbestos again, and they're going to be looking at it, and there will probably be some uses of asbestos that will not be permitted when they're done with this review. But there are some other chemicals here that lots of folks have heard about. Methylene chloride is a very popular paint stripper. Trichloroethylene has been used in degreasing in industrial applications forever. It's being used today. Perchloroethylene is a dry cleaning solvent. It's obvious, any one of you who have ever been to the dry cleaner can smell perchloroethylene. The methylpyrrolidone is an adhesive. It's also used in adhesives and degreasers. Also, 1-bromopropane is also used as an aerosol degreaser, spot cleaner, and stain remover. And this cyclic aliphatic bromide cluster is a flame retardant. It's not used that much anymore, but they're looking at, for reasons that other folks don't want it. They don't want to have products that have that chemical in it, but it's going to probably be restricted in use after they're done with those. The first risk assessments for these 10 chemicals are coming out now. They haven't reached the end point on these 10, but they've already proposed the next 20. And you'll see, these aren't all of the 20. I just picked some of the ones that people might have heard of before. Some of the ones you see here are these phthalate compounds. These phthalate compounds are, most of them are listed on the California Proposition 65 list. There's been a lot of active litigation regarding these phthalate chemicals. You'll find them in a variety of any kind of flexible plastic kind of, you've seen them in jump ropes, you've seen it in exercise balls, they're in all kinds of flexible plastic applications, and they will be looking at those next. The 1,2-dichloroethylene and dichloroethane are also chemicals used in industrial uses. Para-dichlorobenzene, orthodichlorobenzene. I think if I'm remembering correctly, orthodichlorobenzene is in some of those, those cakes you find in men's bathrooms. In other words, and formaldehyde. These are chemicals that are used. People are used to using them, and they're now EPA is going back and they're going to be looking at future use of these chemicals to see how and if their use should be regulated or restricted in the future. This is going to keep going. There will always be another 20 chemicals on the list. They will be checking, and they will keep going. So right now, they really haven't gone through to the end point with any of them, with the first 10, but they're already looking at the next 20, and they're looking down the road at a lot of other different chemicals. So we may find quite a few new rules that will be restricting the use of chemicals that folks are used to seeing in the marketplace. So I think I already covered this. As that TSCA review accelerates, there will be a lot more regulated chemicals. But this regulation will be nationwide. It won't be state by state. It will be there'll be one set of rules, and those rules everyone will be covered by them. But what it does mean is that there'll be an increasing need for information on chemical components up and down the supply chain. As Megan mentioned earlier, she said, if you do this, if you really do look and see what chemicals are in your product, you'll be able to use that information in a variety of ways, and you'll be able to use it here as the TSCA EPA starts regulating old chemicals under the new TSCA. Another thing that is really reaching out into the U.S. marketplace is REACH. REACH is a European Union regulation. It's legislation that's passed by the European Union, and it's administered by the European Chemicals Agency. But it's enforced and administered separately by each member state. It's anybody that's in the European Economic Area, which is larger than the European Union. And REACH stands for Registration, Evaluation, Authorization, Restriction of Chemicals, and I didn't misspell authorization. That's how it's spelled in Europe. REACH is a newer legislation, newer than TSCA. It started in the 2000s, and it uses several of the same kind of concepts that TSCA had. They basically say that all chemical substances have to be registered. So they maintain a European inventory of existing commercial chemical substances, and that is maintained for pre-REACH chemicals that were manufactured or placed on the market before June 1st, 2008. All those chemicals have to be registered before being placed on the market, and they have been. They've gone through that process. If you are a manufacturer or importer of a chemical substance in quantities greater than 1 ton per year, the manufacturers that are going to put them on the inventory are responsible to collect information about the substances, and they have to assess the risk posed by them. It's a fairly rigorous review. REACH, the European Union has been at this for the last 10 years. The U.S. is a little behind in that respect, but and EPA is going to be looking to what things that the European Union has done in the past to evaluate their chemicals, and EPA is going to be using some of that information, but also, and manufacturers of chemicals will be looking at some of the information that they prepared to get chemicals approved in the European Union, and they're going to be using some of that in the U.S. But what is it going to affect more manufacturers in the United States who are exporting chemicals to the European Union is the concept of substances of very high concern. One of the things that you see on a lot of the lists that people get from their end users, they want to know if there are any substances of very high concern in the product. And this is a question that folks are asked at the border. Are there any substances of very high concern in this product? And the member states have established a list of chemicals, they call it the candidate list, of substances of very high concern to human and or environmental health. Then just like EPA does for the toxic chemicals, high priority chemicals under the Toxic Substances Control Act, they prioritize those chemicals on the candidate list for evaluation, and they go ahead and evaluate them one by one. There's over 200 substances on the list of substances of very high concern, and it's always changing. So if you are thinking about exporting things to the European Union, you're going to have to take a look at that list and see if the product has any of those substances on them. Well, a lot of people manufacture articles like chairs and tables and things that, and I'll talk about the definition in a minute, but every time an article comes in, an importer is required to notify if a substance in the article is included on the candidate list of substances of very high concern. They have to notify if it's on the list, if the substance is present in the article above a concentration of 0.1%, and the total amount of the substance present in all articles imported by the importer at that concentration exceeds 1 ton per year. And the idea is, and I think an article is something like, here we see a chair. In this particular, the chair is not the article. This is a conglomeration of articles. So there are little plastic wheels on the chair. That's an article. There are ball bearings in the wheels. That's an article. The little swivel thing in the bottom that the wheels are attached to is another article. The plastic bottom of the chair is an article. The arms are an article. The cushions are an article. Each one of them are individual articles, and they have to look at the 0.1% concentration of a substance of very high concern, and every one of those individual articles in this one chair. But an article itself is an object which, during production, is given a special shape, surface, or design which determines the function to a greater degree than does its chemical composition. So the function of a chair is determined by the fact that you can sit on it and put your arms on the armchair and lean back and swivel around in it. It's the shape that makes the difference, not the chemicals that are in it. So anything with that kind of characteristic is considered an article, and an importer is going to have to notify if there's more than 0.1% of a substance of very high concern in the article. And in this case, the article is every little different piece of this particular chair. How do you get information? Now, the information I have on this slide comes from the European Chemicals Agency. And this is what they are telling people to do so you can figure out whether you do have substances of very high concern in your product. And this is an important thing to look at because this is what you're seeing all over the place with chemical regulation. So this is the recommendation that's going to folks who might have products that have Proposition 65 chemicals in them, that might have other chemicals that are subject to various state lists of community right to know chemicals. What ECA recommends is that article manufacturers and importers obtain the information they need to know to make that notice by what they call proactive requests in the supply chain. So they want you to ask your suppliers who need to, and they want certifications from every one of the suppliers that substances of very high concern are below the 0.1% threshold in the supply chemical or product that goes into that chair. And for the product, the supplier, for that supplier to make that certification, quite often they have to go back to their suppliers, who have to go back to their suppliers. So this is a whole supply chain of information that has to come up to the article manufacturer. So the article manufacturer is going to export into the EU will know whether they can say whether there is over 0.1% of the substances of very high concern in the actual article itself. Now, ECA says that it's not advisable to accept test results without question, and I definitely will concur with that. We're seeing less than scrupulous suppliers send out test results, and if you don't know exactly what was tested, you don't know what the test method was, and you don't know what the laboratory was, you might not be getting what you think you're getting. And ECA thinks that this is a big enough problem that they're bringing it to people's attention. So for testing, ECA recommends standard methods in accredited laboratories, and a lot of folks are looking at maybe even periodic retesting, simply because suppliers could change, different people can change, and different raw materials can change, and what might pass one week might not pass the next year. So this is what ECA is recommending. This is what I see a lot of people doing. I'm going to switch gears here to OSHA safety data sheets. In 2012, OSHA changed the requirements that it has for safety data sheets and the information that must be provided in data sheets. Manufacturers and importers must prepare these safety data sheets. And what I see a lot of people are messing up is when they're importing chemicals or products from overseas, they are taking the safety data sheet from the supplier and distributing it to folks. And one thing I need to let people know is that if you are the importer, you are the one that's responsible for that safety data sheet. So if the data sheet is incorrect, there's incorrect information, or if the data sheet is correct for a different country, it doesn't necessarily mean that that data sheet is correct for the United States. There is a globally harmonized system for safety data sheets, but that doesn't mean that individual countries within the world don't have their own standards. And the U.S. has its own criteria, and although it's very similar to that of other countries, you need to make sure that any safety data sheet that you get from a supplier, someone who is exporting to you, that data sheet meets U.S. standards. Another thing I want to talk about is that, yes, a lot of people use safety data sheets as a guide for what chemicals are in those supplied products. But you have to realize that OSHA has a different goal when they have people put together safety data sheets. They're not asking for everything that's in that chemical, impurities or whatever. They're asking for chemicals that are there above a specific percentage. And I think the lowest percentage they have is 0.1%. So you're not usually going to find a listed chemical if it's present in the product at less than 0.1%. But Proposition 65 wants to know if that chemical is present at all. And TSCA wants to know whether that chemical is present at all. So there's the information that you get on safety data sheets is not necessarily adequate for complying with some of these other chemical regulation requirements. And I also want to let people know there a lot of regulatory information can be found on OSHA safety data sheets, but the section where regulatory information is provided, Section 15, is not mandatory. OSHA does not enforce that section, which means that the manufacturers and the providers of safety data sheets can put whatever the heck they want in this box. So the information is not necessarily complete. It doesn't necessarily provide you all the information you need to comply, for example, with California Proposition 65. There are no consequences also if they tell you something wrong. So if they tell you that the product is on the TSCA inventory, there are no consequences if they're wrong because OSHA doesn't enforce that part of the safety data sheet. So you want to make sure that that if you're getting this information that you double check it. It's a good guide. It's good to be used. And if you, but I would not use that as your only source of information on the regulatory requirements applicable to a particular product. Okay, so we're ready to wrap up here. I think we have a couple of questions. What I wanted to say here is that, look, the regulation of individual chemicals has been and will continue to increase. The retailer requests that we're getting for information on chemical components will likely increase, and they're going to start asking for more precise information. So the information that the responses that people have been giving in the past, which is, well, we didn't add any chemicals to this product before we gave it to you. Well, over time, probably that won't cut it. Folks who are supplying raw materials, folks that are supplying products to retailers are going to have to look back into the supply chain to get more precise information about chemicals in the product itself. So what we're seeing is a lot more normal sharing of the chemical and up the supply chain, and the manufacturers are going to have to get a lot better information from the suppliers over time. Not only that, more product testing may be necessary so that that folks can get good information, that they can reliable information. One of the things that I have seen that are a problem for a lot of folks is that the products that are being tested, you're getting test results from sketchy labs, maybe from overseas, and you know, it wouldn't hurt at all to double check those the first couple of times to make sure that who you're working with is reputable. And that's obviously up to individual decisions, but I think a lot of folks are seeing that some of the information that they're getting from smaller companies overseas that are not very sophisticated is less than sufficient for companies to be able to comply with these regulations. Megan, I don't know if you have had a chance to look at some of the questions. Is there any question that you'd like to read here that you think might be of use to other folks?
Yeah, thanks, Amy. So this is Megan. So I have received a couple of Prop 65 questions. I haven't worked my way through them yet, but I absolutely will take a close look and respond directly on those questions here shortly. So I think that wraps up our webinar today. Thanks so much for joining us. We hope the information provided was helpful for you and your organization. If you haven't already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. So as a reminder, the program has been approved for CLE credit in a number of states. A recording of the webcast will be available tomorrow for watching and sharing, and once available, a link to the recording will be emailed to you along with the certificate of attendance. So thanks so much. We really appreciate your attendance, and again, I'll be responding directly to any questions you submit. Thanks so much.